All right, let's jump straight into this explainer. We're mapping out the incredibly complex and super high-stakes landscape of India's intermediary liability laws. Now, before we get completely lost in the legal weeds, let's just define what intermediary liability actually means in practical terms. Basically, we're unpacking exactly what keeps tech platforms protected from liability. Why the app itself doesn't get sued for something a user posts. And, more importantly, what actually causes them to lose that legal shield. Because whether you're using a secure messaging app, endlessly scrolling through social media, or watching digital news, the platforms you interact with every single day are governed by a rapidly shifting set of rules.
So here's our roadmap for today. 1. Decoding the IT Rules 2021. 2. SSMIs and traceability demands. 3. The Fact-Check Unit Amendment. 4. The Comra Judgment Reasoning. 5. Supreme Court Status Check. And finally, 6. The Deepfake AI Frontier.
Let's start with Section 1, Decoding the IT Rules 2021. To really grasp this, we have to understand how due diligence and safe harbor are enforced. Safe harbor is essentially that legal immunity I just mentioned, but to keep it, platforms have to play by strict rules. The 2021 law fundamentally splits the internet into two distinct tiers. On one side, if you're a standard platform, your baseline obligations are pretty straightforward. You publish clear terms of service, appoint a grievance officer, and stick to strict takedown windows. That means you've got 36 hours to remove content once you get a court or government order, and a much tighter 24-hour window for sensitive stuff involving nudity or morphed images. But if you fall into the heavier category of a significant social media intermediary, an SSMI, the government demands intense, localized accountability. You actually have to hire a chief compliance officer who lives in India. And get this, that person can literally be held personally liable and face jail time if the platform breaks the rules. You also need a nodal contact person, strictly for law enforcement, a resident grievance officer, and you've got to submit monthly compliance reports.
Now you might be wondering, how does a platform suddenly find itself burdened with all those heavy SSMI rules? Well, it all comes down to this number: 5 million registered users in India. That is the exact threshold that triggers these heightened obligations. It's a very carefully chosen metric. It basically gives smaller startups some breathing room to grow without getting crushed by compliance costs, but it simultaneously forces the giant tech monopolies to answer directly to local authorities. The second a platform crosses that 5 million user mark, the regulatory switch flips and they step into a much more demanding legal reality.
And the rules actually adapt for different types of media, too. For digital news and OTT streaming platforms, the law establishes a specific 3-tier digital media ethics code. So instead of just standard takedowns, there's a whole ladder of regulation. It starts with publisher-level self-regulation at Step 1. Then it moves up to a self-regulatory body of publishers at Step 2. And finally, it culminates in an oversight mechanism housed directly within the Ministry of Information and Broadcasting. Think about what that means. The final arbiter of digital media ethics isn't an independent judiciary, but the executive branch of the government itself. That is a massive shift in how media is regulated.
Moving on to Section 2, SSMIs and traceability demands.
This is where the abstract law collides with the very real tech sitting in your pocket right now. Traceability sounds pretty straightforward on paper. It's a requirement that a messaging service must be able to identify the first originator of a message whenever they are compelled by a judicial or specific government order. In a world where millions of messages are forwarded every single day, this essentially means finding the patient zero of a viral text. But technologically and legally, traceability sets off a massive clash between state security and user privacy.
We are looking at a classic, incredibly high-stakes standoff here. On one side, law enforcement urgently needs to track down the originators of horrific crimes, things like child sexual abuse material or immediate state security threats. But platforms like WhatsApp argue that, mathematically speaking, you just can't build a backdoor only for the good guys. Traceability inherently requires breaking end-to-end encryption for absolutely everyone. It effectively turns a secure, private tunnel into a glass house. So this pits urgent policing demands right up against the constitutional right to privacy established in the landmark Puttaswamy case. It's a live, active doctrinal fault line that is still unresolved today.
Which brings us to Section 3, the Fact-Check Unit Amendment.
This is where the battlefield shifted directly from privacy to a massive debate over censorship and free expression. Under a 2023 amendment, the government authorized a fact-check unit to identify online content related to the business of the central government and explicitly flag it as fake, false, or misleading. Think about how broad that language is for a second. That could mean economic data, political speeches, public health policies, the whole shebang.
And if the government's own unit flagged a post as misleading, the platform had to delete it or instantly lose their legal safe harbor shield entirely. A government fact-checking designation suddenly became a high-stakes, direct compliance trigger for every platform out there, which predictably prompted an immediate legal challenge.
And that leads us to Section 4, the Kamra Judgment Reasoning.
Enter Kunal Kamra v. Union of India. A stand-up comedian, joined by several media guilds, challenged the state's power to unilaterally police truth. The legal journey of this case was wild. It started with the initial amendment in April 2023. By January 2024, the Bombay High Court delivered a split verdict. One judge struck the rule down, citing censorship concerns, while the other dissented, feeling the challenge was premature. Because of that split, which really just proves how legally polarizing this amendment was, even among High Court justices, it went to a third, tie-breaking judge. Finally, in September 2024, that tie-breaking judge struck the rule down entirely.
Now, the reasoning here is just a masterclass in constitutional law. The judge ruled the amendment violated Article 14, our right to equality, because it subjected digital media to way harsher rules than traditional print newspapers. It also violated Article 19(1)(a, the fundamental right to free speech, because terms like misleading are just so vague that they create a massive chilling effect on legitimate political dissent. I mean, imagine a platform trying to interpret what's misleading in real time without getting sued. On top of that, it violated the freedom to practice a profession, failed the proportionality test regarding the right to life and personal liberty under Article 21, and was ultimately declared ultra-virus. That's a fancy way of saying the government simply didn't have the legal authority under the Parent IT Act to make this specific rule in the first place.
But out of all that dense legal reasoning, the court made this notably sharp, profound observation. They literally stated that citizens have no constitutional right to truth. That is a fascinating philosophical boundary. It basically means a democratic government cannot act as the ministry of truth. When a state body acts as the sole arbiter of facts regarding its own conduct, it inherently creates a massive conflict of interest. The court essentially said the state is just not legally obliged to police misinformation on its own behalf.
Let's look at Section 5, Supreme Court Status Check. Because as of today in 2026, we absolutely cannot treat this as settled doctrine. Law is a living thing, and this case is still very much breathing. The central government obviously appealed the High Court's decision. On March 10, 2026, a three-judge Supreme Court bench agreed to examine that appeal. However, and this is crucial, they declined to stay the Bombay High Court's judgment. In legal terms, this means the Supreme Court refused to hit pause on the lower court's ruling while they review it. So, as of right now, the government's fact-check unit provision remains completely dead in the water and totally inoperative.
Finally, Section 6, the Deepfake AI Frontier.
Let's pan out and look at the absolute bleeding edge of intermediary liability. Because while the courts are busy untangling the rules of 2021 and 2023, the technology of 2026 is just racing ahead. Reports indicate a strong regulatory push toward a brand new category, synthetically generated information, or SGI. This is squarely targeting deepfakes. SGI is a vital new frontier because a deepfake isn't just a false statement on a page, it's a completely synthetic, fabricated reality that actively bypasses our normal human ability to verify the truth. Because of this, platforms are likely going to face unprecedented, ultra-fast takedown obligations specifically tailored to AI. It's going to change the compliance landscape all over again.
Which brings us to the end of our explainer and leaves us with one critical question to ponder. As technology exponentially outpaces legislation, with end-to-end encryption baffling tracing efforts and AI generating entirely synthetic realities, how will the law ever truly catch up? The rules are written, struck down, and rewritten, but the internet never stops evolving. Thank you so much for joining me in unpacking this complex architecture today. Keep watching this space because this story is far from over.